Professor Beery, if you'd like to begin, even though they have not signed on, we want to be respectful of everybody's time this evening. So I'm sure they will join us as the program has started. But if you would like to begin.
Okay, sure. Thanks everybody for being here. We do have two distinguished alums who we're hoping will join us. And if they are able to do that, I'll introduce them at that time. Meanwhile, we do have some members of our faculty here for a discussion about life under the court, right? Under the court, the U.S. Supreme Court as it is currently constituted. As we all know, there have been major tectonic changes and developments in the past couple of years to American constitutional law. Is very much in flux. And one of the common threads that might run through our discussion today would be the issue of stare decisis, which is something that we teach in law school as a bedrock principle undergirding American law and constitutional law. But I think there, for obvious reasons, there are some serious questions about stare decisis at this point, which of course is the principle that rulings that have already been made and reasoning that has already been hashed out, right, should be followed to the extent possible. So let me introduce those who we do have here on the panel. Professor, although many of them don't need an introduction, but I'll go ahead anyway. Professor Michael McDonald is a retired brigadier general and has worn many, many hats, including assisting the governor with a number of different issues. Professor McDonald has taught Homeland Security and constitutional law, and so is going to be talking about some of our constitutional issues. Tonya Krause-Phelan is not only a professor, but is our academic dean and teaches criminal law and criminal procedure. Criminal procedure, of course, is another version of constitutional law, right? Fourth, Fifth, and Sixth Amendments. Professor Bill Fleener is joining us, and I'm so grateful that he is, because one of the recent Supreme Court developments has to do with what's in his wheelhouse. In addition to running our extern program, Professor Fleener also teaches administrative law, so is grappling right now with the recent Supreme Court overruling of the famous Chevron case. I myself am Brendan Beery. I teach constitutional law here at Cooley. My intent was to introduce our alums first, but again, we're still hoping that they can get on the panel. I'm going to try to keep this to 45 or 50 minutes, or to 5:45 or 5:50, actually, to be more accurate, because some on the panel, and I know some of our guests as well, have commitments starting at 6 p.m. So with that, I'm going to turn it over, I think, to Professor Fleener first, since, again, the most recent shakeup has to do with your area of law.
Thanks, Brendan. Yeah, I think we have a bit of an earthquake in the administrative law cycles, and the question of what does precedent mean is certainly applicable to that. So I want to talk briefly about three cases that are fairly staggering to administrative law. Of course, Loper Bright, the Chevron deference. We'll get to that. But a couple others along the way. Corner Post versus the Board of Governors. If you're not familiar with this case, it was a Federal Reserve case. The details in all these cases tend to be fairly minute because they're overruling major principles of law that were longstanding, but it had to do with credit card charges for a gas station. And what the Supreme Court held in that case was, against decades of precedent, was that the statute of limitations for administrative actions against administrative agency actions were no longer bound by the 6-year statute of limitations contained in the Administrative Procedures Act. That's been the law for a while. If you think about statute of limitations, it's kind of an odd thing because there's no injury, and statute of limitations typically happen at the time of injury. And in fact, that's what the Supreme Court has now held, is that agency action or injury to the litigant now starts the 6-year clock. But what that means practically is that administrative agency actions have no finality. In Cornerstone, the entity that challenged the action did not exist within the 6-year time frame of the passing of the rule. They began business after that. People would argue they began in an enterprise with existing rules, had knowledge thereof, and maybe shouldn't have been able to challenge them. The Supreme Court said no. Their injury is when they entered into that field that was governed by that rule, and the 6-year clock starts then. Practically, what that means is that people can form corporate entities, enter into an enterprise that has established rules, even decades-long established rules, and as soon as they're injured, they have 6 years from that time to challenge the rule, and so rules will not have any finality, as it were, based on that. The second one I want to talk about quickly is jarcossy. Jarcossy is an SEC case. People are accused of fraudulent trading practices and setting up a financial instrument. And again, the details aren't particularly important, but what was important is that the Supreme Court determined for that case that the SEC statutory layout allows the SEC to pursue actions either within the agency adjudication, or in constitutional courts. And in jarcossy, they chose to litigate it in the agency and sought sanctions or penalties. Supreme Court said that the penalties were akin to common law fraud, and therefore violated the person's right to a jury, so aren't juries at administrative agencies, and that case had to be heard by an Article III court. I think with a lot of these cases, we don't know what the ramifications are of that. The Federalist Society today published a blog, and they give it a little twist, which is kind of interesting. They don't call it sanctions or fraud, they call it penalties. And if you think about regulatory agencies, and some penalties are based on fraud, some penalties aren't based on fraud. But if we're expanding it to the idea of penalties, then almost all regulatory actions would have to happen in Article III courts. There's at least an argument under jarcossy that could be the case. There are other people obviously arguing that you have to have a criminal analog in order for it to apply, but we'll see. But either way, it's upset decades of precedent and done away with the idea that when you have a broad regulatory scheme, the right to jury is set aside and it can be adjudicated by an administrative agency. And then, of course, we get to Loper-Bright. Loper-Bright, again, details not particularly important. It's about people on boats who were auditing whether they were catching the right fish and how many fish and traveling in the right waters and things like that. And the question was, who paid the salaries of those people for a long time? And there's some confusion. There was one statute that clearly allowed it and another one that didn't. So the agency didn't do a good job with that. But the Supreme Court took that opportunity to do away with the Chevron doctrine. Again, the Chevron doctrine, most of us, I think, know, but it allows agencies to make reasonable interpretations of ambiguous statutes under the theory that Congress does that somewhat intentionally so that statutes can be implemented, and allows agencies to legislate in that space. And Loper-Bright says, no, there is no deference due to the agency's interpretation. They are in as good a position to make a determination as the experts in the administrative agency. And another factor, I think, with this Supreme Court is they think they're experts on everything. I think Professor McDonald's going to talk about the gun case where we see Terrence Thomas becoming an expert on firearms. So I think we're going to see that. I wanted to mention two other quick things. Ohio versus the EPA. This is not a full merits case. It's a shadow docket case, and we probably don't have enough time to get fully into the shadow docket. But the EPA asked for the ability to implement a Clean Air Pact where states had to supply plans so that they weren't polluting their neighbors. Some states objected. The 11th Circuit said, EPA, while we're hearing this appeal, you can implement the plan. Supreme Court jumped in and said, no, we're putting an injunction on that plan. And the shadow docket, we could probably do a whole other session on the shadow docket and all the things that are happening there, but we won't get in there. And then very lastly, I think kind of overriding all these and intertwisting with these and some of the other cases you hear is the rise of the major questions doctrine. The creation of the major questions doctrine is probably a better word. It's specifically identified in 3 or 4 cases over the last couple of years, kind of tangentially identified in some of the others. And basically what it stands for is if we, the court, think it's a big deal, you can't do it. And that's a big change. And so, well, we can't do it unless Congress specifically authorized it. I should be careful about the terms. So I think we see, and I think the overriding effect of the administrative law cases is I think the federal courts are unprepared for the amount of litigation they're going to have to take on dealing with all of the potential regulatory actions, dealing with the removal of statute of limitations, and dealing with courts not deferring to agency or interpretations. All those things are going to significantly increase administrative law adjudication in the constitutional courts, and I don't think they're ready for it. But we'll see what happens. So I think that's where we are as far as we can tell.
Thank you. Can I introduce myself?
Yes. Hi, Judge. How are you?
Good. I'm sorry I'm late. I had a heck of a time getting on this webinar, punching this and that and the other thing. I'm not very savvy with that sort of thing, but shall I introduce me?
Yeah, I have a brief introduction. I was just waiting hoping you could sign on, but yes, this is one of our distinguished alums, Honorable Terrence Bronson. Is a 1976 graduate of the James V. Campbell class. He is a retired judge from Monroe County, Michigan, presided over the Veterans Treatment Court and serves on the Michigan Military Appeals Tribunal, and retired in 2021 as a captain with the Naval Reserve. Did I get any of that wrong? Or
2011, but yeah, that's okay. I'm getting paid for it, so it doesn't matter.
Okay.
Retirement pay. I should tell you that constitutionally, as a trial court judge, the only constitutional issues I faced were search and seizure, the sort of thing the police, were they acting within the scope of their duties constitutionally and so forth. The other thing I came across quite a bit, Monroe is right next to Ohio, and I've had to enforce a lot of Ohio judgments in Michigan. And many times I had to explain to litigants and attorneys the full faith and credit doctrine. Look, yeah, you don't like this ruling, but it's there, and you have to give full faith and credit to the Ohio courts who adjudicated the case and had the judgment. So that's been my experience. And otherwise, I've kept up on things like the Chevron doctrine. I found that very interesting that what the court did. Plus, I've got at least one issue that I would really be neat to discuss once you get to it. I didn't email it to anybody, but it's just I'd like to hear everyone's opinion on it because it's going to be an interesting one once if it makes it to the U.S. Supreme Court.
Okay, great. Yeah, if you wanted to go ahead and discuss that now, that would be great.
Yeah, well, the Texas border issue. Governor, I think it's Abbott, is his name, sent the National Guard to guard the border, saying that Biden refused to enforce Article 4 about the federal government duty to protect states from invasion. And he said, well, you're not doing it, so I'm going to send my guard down. And now he's being sued by the federal government for overstepping his bounds, for lack of a better term. So it'd be very interesting to see how that progresses. If the federal government doesn't do it, can the state do it? if we were invaded by Canada tomorrow, should we, we as Michigan send out the National Guard to the Ambassador Bridge or something? So it's just, I just love to hear opinions on that.
Good issue. So the invasion of the Mounties, huh?
Yes, right.
Well, let me throw that to Professor McDaniel, and for your thoughts on that and Second Amendment and other issues that you have on your mind.
Well, let's start with that one because I think it's an interesting issue. Judge Bronson's referring to Article 4, Section 4 of the U.S. Constitution, which states that the U.S. shall guarantee to every state a Republican form of government, and then says, next clause, and shall protect each of them against invasion. So Governor Abbott, Greg Abbott of Texas's argument is that the federal government has failed to do so. And since the federal government has failed to do so, then he is in the right to act as the commander-in-chief of the state forces to use those forces to repel invasion. There are a couple things wrong with this, obviously. First and foremost is this doesn't fit the definition of an invasion. Invasion has a very specific definition under international law and under military law having to do with armed troops infringing upon the sovereignty of another nation, almost always including the geopolitical border between two nations or of a nation, which doesn't exist here. The circus we've seen on the southwest border involves individuals desperate to get into the United States, either at border crossings or at other locations other than border crossings. And Governor Abbott, as I said, went through a political circus of responses, not just putting state guard troops on the border, but also putting barriers in the river, which violate a couple of other federal statutes, including the Navigational River Statute, which were dangerous as well because they had sort of metal flanges on these buoys in the middle of the river, which could injure people and did, and a couple of people drowned as a result. The other sort of constitutional issue there is what's he doing putting troops on the border? And there has to be a distinction made between the types of troops. As Professor Beery mentioned, Judge Bronson is on the Michigan Military Appeals Board and is cognizant of the issue having to deal with the National Guard and the use of the National Guard. The U.S. Supreme Court, quite a few years ago now, I think it was 1991, in a case called Perpich versus Minnesota, or excuse me, Perpich versus Department of Defense. Perpich was the governor of Minnesota at that time, and he sued the Department of Defense trying to keep Minnesota guardsmen from being used in Honduras, as I recall. And he was unsuccessful with that. And the reason he was Nicaragua. And the reason he was unsuccessful with that is because under the Article 1, it indicates the powers of both the executive branch and the Congress having to do with state militias and the ability of the executive branch to call up the National Guard. So in this case, Governor Abbott, there's two states really, California and Texas, that have such a large state and a large budget that they can have a state guard separate from the National Guard. And so what Governor Abbott has done is place state guard troops on the border. They are not in any way federally recognized troops, and therefore he can act with impunity in terms of how he directs them to be used as the state commander-in-chief. But he could not use federal troops for that purpose. Would
it make a difference then if he used National Guard?
Yes, I think he could be easily precluded from using National Guard troops. It would be the same as happened in Alabama and Mississippi when the governors tried to call out National Guard troops to prevent integration of either high schools or universities. And Presidents Eisenhower and Kennedy in those cases immediately federalized those troops and sent them back to their barracks to keep them from being used in a state capacity, which would be contrary to the federal policy.
Interesting. Very interesting. So you think that the Supreme Court will back the administration?
It's hard to say with this Supreme Court, but
No bets, huh?
I will say, Judge, that I think they should.
Mhm.
I think it's clearly a matter of federal law. And I think that the term of art in the Constitution doesn't mean individuals, non-military individuals coming in from Mexico, Canada, or anywhere else.
Thank you. Thank you. That's well, we'll see how the chips fall on this one, right?
Right.
And I was wondering too, Professor McDaniel, if you could check me on this, but when you're talking about the term invasion, a case came to mind, the case when Congress tried to suspend habeas corpus after 9/11. And it's been a while since I looked at that, but if I'm recalling correctly, the court went to some pains to distinguish between an attack and an invasion, because you can only suspend habeas corpus in times of rebellion or invasion. And the court said, look, invasion means you look out the window and there are foreign troops out there. Right. That's not, so even what happened on 9/11, obviously, as horrific as it was an attack, not an invasion. Do I have that right?
You do, and that's an excellent point. I appreciate you bringing it up.
Yeah, I thought it just came to mind because of what you were saying, but did you want to pick up with any Second Amendment?
Sure. So
I'm sorry to interrupt. I just say that Manisha is here. Can I briefly give an introduction to Manisha and then come back to you?
yes, absolutely.
Hi, Manisha. Apologies to both our alums that you had some trouble logging on, but let me introduce you. Thank you so much for joining us. Manisha Vadgama is a 2010 graduate of the James Witherell class, is a Deputy Attorney General in California, and before that was a Deputy District Attorney for the City of Los Angeles. Also holds a bachelor's degree from University of California, San Diego. And Manisha, I might say that with your resume, a large city AG's office in California and the Attorney General's office in California sounds a little familiar. you might be headed to high places here.
I hope
thank
not.
you for joining.
I hope not. Thank you guys for having me. It's a privilege being on this with all of you.
Thank you. And we'll come right back to you as soon as Professor McDaniel is done with his presentation.
Thank you, Professor Beery. So I wanted to talk about the Second Amendment just because in common law, by the time we get done talking about the Fifth and 14th Amendment on due process, talking about equal protection clause of the 14th Amendment, talking about the First Amendment, the term's over. So we rarely get to get into detail on the Second Amendment. But Professor Beery sort of gave me the green light today. And the reason I want to talk about it is because, as all of you who have taken common law recently will recall, when we talk about the Dobbs case, we talk about the question of whether or not some right is deeply rooted in our history and tradition, as the courts use that term. So to set the stage here, this is the case of Zaki Rahimi down in Dallas, Texas. He's a drug dealer, and he beats up his girlfriend. He beats up his girlfriend. He pushes her into the car. She bangs her head. An eyewitness is there filming this. He retrieves his gun and starts shooting either at his girlfriend or at the eyewitness. Not clear which. Luckily, he doesn't hit either of them. She gets a restraining order. There is a federal statute that provides for a restraining order against an individual where they represent a credible threat to the physical safety of any intimate partner or a child of the partner. And in this case, we had both, because Zaki had a kid with his girlfriend. So she gets the restraining order under federal law. And of course, he immediately violates it, going to her house at night and calling her on multiple occasions. And then after that, he goes off the deep end. He threatens another woman with a weapon. A former customer of his product trashes him on social media and in person. So he fires shots into that individual's house. He and a friend are at a fast food restaurant when the friend's credit card is rejected. So he starts shooting in the fast food restaurant, and he's firing a weapon a couple of times. needless to say, as part of their protective order, he is not supposed to have any firearms. So he is arrested and convicted of that. But Zaki Rahimi's attorney says, well, we're in the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals is always willing to listen to what our new Supreme Court is doing. So they file an appeal based upon the Bruen case. And the Bruen case, of course, from just 2 years ago, looked at the New York state law, which was a state which said that it was not a shall issue state, was you had the state had discretionary authority on issuing a concealed license. And in an opinion by Justice Clarence Thomas, he sort of not only flipped the law, the longstanding law in the state of New York, almost 100 years old, on its head, but he also sort of flipped the deeply rooted test, because what he said wasn't that you had to go find that your Second Amendment right extended as a matter of history to this. He said that it was up to the state, the burden is on the state. So there's this presumption of unconstitutionality under the Second Amendment. So the state has to show that there is a law that specifically fit. And as he said, the government must establish that the challenged gun law is consistent with this nation's historical tradition of firearm regulation. Well, there is no law disarming domestic abusers going back in history. So the Fifth Amendment said, this law is unconstitutional. Now, one quick thought on Bruen, and then I'll get into a little bit more detail. But in Bruen, they seized upon part of our case that we saw in both Heller and McDonald, where the big problem, remember, when you're looking at that, when we had the original case by Scalia and the McDonald case by Alito, was we don't use muskets anymore. They wanted to extend this right to self-defense, primarily in those cases to handguns. But then, of course, they didn't look at they didn't define weapons of self-defense. What they said instead was that it extends prima facie to all instruments that constitute bearable arms, even those that were not yet in existence. So there is an incredible illogic to this, and that is that on the one hand, they are endorsing the idea that any weapon not yet thought of historically would be included in the protection of the Second Amendment, but any law which would limit these unknown firearms because they haven't been envisioned yet, whether we're talking fully automatic weapons, bump stocks, or whatever the hell they might be, they haven't been envisioned yet, but that law has to rather precisely, according to Thomas's opinion in Bruen, put preventions or limitations on those types of weapons. And of course, it could not. So we have a little bit of fresh air from the Supreme Court in the Rahimi case. Justice Roberts wrote the opinion. It's an 8-1 opinion. Not surprisingly, the dissenter is Clarence Thomas. And what they said was that their limitations on the Second Amendment and Bruen, quote, were not meant to suggest a law trapped in amber, which is a great line, and we don't always get them from Roberts, but that's a pretty good one. It's the idea, remember the old fossils, you see the fly trapped in amber, and it's been that way for thousands of years. So he's trying to say we're not so fossilized or calcified that our laws cannot be looked at. And he described two types of laws that existed. I'm talking fast because we're under time constraints. Two types of laws that existed back there: the idea of the surety laws and the law and criminal penalties. And a surety law was, under the old cases, you could require somebody to post a bond if they were going to have a firearm, especially if they were if it was somebody that they thought could be a danger to the public. And then secondly, were the idea of criminal penalties. And so he said it didn't have to be example. He said the court should focus on the purpose of the regulation and the burden that it places on the Second Amendment right to bear arms. So there's at least some breathing room there. So that's the good news. And then we've got a number of dissents. The most important, I think, which is Justice Barrett. And Justice Barrett makes it pretty clear that, let me find her language here. she said that the problem with the historically rooted test is that we are requiring, quote, overly specific analogs describing serious problems. And she says, if we are making 21st century regulations based on 18th century problems, then we're going to have no laws that regulate guns. And she was clearly against that. So there seems to be a bit of fresh air there. But getting back to Professor Beery's theme here about the loss of stare decisis, that seems to clarify and say, okay, now this is going to be the test and we're going to continue it. But there is a case decided by the Supreme Court a week earlier. Rahimi was on June 21st of this year, and there's a case called Attorney General Garland versus Cargill on June 14th of this year, involving ATF's regulation of bump stocks. Now, it's not a Second Amendment case. It is a Professor Fleener case. They are looking at the authority of ATF to make these rules. But the concern I have with that is at the end of the opinion, when they're looking at the concept of a bump stock, the court specifically says, after spending some time describing a bump stock, says that with a bump stock, the weapon is not firing repeatedly based on a single pull of the trigger. And even if it did, it's not automatic. The way that a bump stock works is you put the stock against your shoulders like you do with any long gun. And when you do so and you pull the trigger, the expellation of gases causes a certain kick against your shoulder. Everybody who's ever fired a weapon has felt that to some degree. A long gun has felt that to some degree. And it's that expellation of the gases from the round that cause the weapon to come back against the bump stock, which reloads the weapon. So in my mind, that is just as automatic as having a mechanical mechanism, not to be redundant, within the weapon itself, recurring every single time. So we've got a case here where the Supreme Court not only is ignoring stare decisis, they're also, they're showing the problem with rejecting Chevron deference, because the court is in essence making stuff up. They're acting like they're the experts as opposed to the ATF. And they're saying, well, this isn't really an automatic firing of a weapon. And it isn't really a single pull of the trigger, even though it is. You're just holding the trigger back, and that causes the weapon to keep recycling against your shoulder and rearming it every time. So I'd like to say that there's a little bit of light there. And maybe there is in terms of the deeply rooted test being a little less specific than the onerous burden in Bruin. But the court is still going on its own path, rejecting both stare decisis and sort of in a rather activist way, willing to make law rather than relying upon the administrative agencies who have the expertise. Thanks.
Thank you. Excellent.
Quick question, Professor. The idea of gun control being a public health issue. Can you, I've read that is some states are calling it a public health issue, not a weapons issue. Will that mire things up?
I
Yes.
don't know.
Okay.
I don't
In
know.
a word, yes.
Yeah, so the issue is, if you look at the definition of injurious to public health and or even epidemic under a lot of state public health laws, they were written back in the 1900s when we had that first major influenza outbreak with the Spanish flu, as it was called at that time. And so they were written very broadly. And the way those laws are written, of course, would include systematic or cumulative injuries to a public health. And you can certainly make that argument, I think, either for deaths of young men and in many areas, and or the use of automatic weapons themselves. But, even here in Michigan, what happened, of course, when we had COVID and Governor Whitmer relied upon the older emergency management statute, which did not have a deadline in it. The court just rewrote that statute rather quickly. So it's a potential argument. It'll be interesting to see if it goes forward and if it's ever successful. I don't know that we've got the political will to do it, but I would love it if we did.
Thank you.
Thank you. And fantastic. Okay. And so now, Manisha Vadgama, the floor is yours for thoughts about life under the current Supreme Court and where we're going.
Yeah, so I thought I would sort of bounce back and forth with Professor Krause-Phelan because she's the expert. But, you know, we have this Grants Pass Oregon case that I think has been a significant, well, homeless in general, it has been a significant issue in California. I was reading up on like just the statistics of what we're dealing with here. It's currently 181,400 people are homeless living out in the streets in encampments, which is a 40% increase in the last from just 5 years ago. So it's a major issue. Our governor, you know, Governor Newsom came out with a statement about how this sort of tightens the ability for law enforcement to be able to start regulating and controlling, you know, issues with the homeless population, which I'm sure most of you know. And Professor, you could probably give it much better service that it needs as to what the case means. But basically what we're seeing here in California is it even being implemented, even though this case has passed? So maybe I'll just jump in, Professor, when you're done with the main overview of the case, if that's okay.
I think one of the things we wanted to point out about this case is it sort of kind of does away with a lower court's decision that you could not criminalize or punish someone for being homeless if there was no available housing or place for them to go in the jurisdiction. And in Grants Pass, what the Supreme Court did is they came out and said, look, we're not going to get into that fact-finding mission here. It is absolutely okay for a jurisdiction to punish, criminalize, and punish someone who violates the camping ordinance, right? Or the court, or statute, which essentially flies in the face of some long-standing precedent we have that we do not criminalize status, right? And if you're homeless, that's a status. And so that's what's so startling about this particular case is in the name of trying to do away with imposing a duty on the courts to fact find whether a jurisdiction has a certain percentage of beds available for homeless people to sleep in, they say, no, we're just going to say it's okay for you to have these statutes in the first place and then convict and punish them for that statute. So I think that's what really concerns me about the case going forward and what other jurisdictions might look to quote unquote criminalize status situations.
One of the things I found really fascinating is on the first day, so this case comes out and the next day I'm walking to court in downtown LA and literally like you have to jump from street to street to like avoid encampments. It's just that bad when you're walking to court. And on my way back from court, the LAPD was literally clearing out one of the streets. And so I followed up with, you know, some of the officers that I know over there, and they're like, our policies haven't changed. Because one of the, at least in Los Angeles County, is they're saying, yes, now we have the ability to do it, but even if we do arrest them, even if we do cite them, the local district attorneys aren't doing anything about it. So we're dealing with, I'm sure you all have all heard in Los Angeles, and there's a big political district attorney fight race out here, and so law enforcement's having a really hard time. Well, the Supreme Court can pass this, but it doesn't mean anything for us because if we're citing them for a misdemeanor, it's not getting filed, they're just getting released, and it creates more of an issue. So, and I've followed up with the LAPD, the Sheriff's Department, you know, the big local agencies that are heavily dealing with the homeless population, and they're sort of stuck, which I find, you know, fascinating for us, probably not for them, but the fact that like this case can pass and still nothing changes for them because of their local politicians here.
Yeah, and I should say that interestingly, the case went to the Supreme Court on an Eighth Amendment violation issue, right? Does it violate the Eighth Amendment? Is it cruel and unusual punishment to punish someone for sleeping in the park, right? And one of the things that's basic that we learned the first week of criminal law, the first week of law school, right, is that proportionality is built into our criminal laws. And so is it, coming back to this idea of punishing a status, is it okay to punish someone criminally for being a certain status, i.e. homeless? And so the Supreme Court didn't find any Eighth Amendment violation, but as we said, and as you point out, what's going to be really interesting is how jurisdictions try to pass and enforce laws with respect to homelessness and what individuals who are homeless do in public and how that will be penalized going forward.
Right. Yeah, it'll be really interesting to see how it plays out, especially with the new election coming up.
Well, in large cities that have large homeless populations, this is going to be an issue, how they use this case to their advantage or not.
Right. And I think for us here in, in California, they're getting a lot of, public outcry where, we all know how it is. Once it starts affecting a certain type of population, then things blow up, then things become problematic. And so homelessness is leaking into the more affluent neighborhoods. And now it's becoming this issue, which, we can spend hours talking about the issues with that. But now they're putting political pressure on local politicians, local district attorneys, like, hey, what's going on? I read this whole LA Times article where, someone in Beverly Hills was complaining, like, why are these homeless encampments outside of my, my door down the street from me when the Supreme Court has given you essentially the authority to do this and nothing's being done. And so there's so many layers and levels to this. So it'll be really interesting to see how it all plays out in November.
Thank you. Professor Krause-Phelan, did you have any other criminal type cases before I ask Director Mullins if there are any questions for the panelists?
I have three quick ones, but I wanted to make sure that Judge Bronson had the opportunity to cover everything that he wanted to cover.
Oh, I got several things, but I feel like I'm sitting at the feet of wisdom here.
Well,
No,
I will
it's
defer to
very
you.
interesting. Pardon me?
I'll defer to you so that you can talk about what you want to talk about.
Well, if we have another discussion, and I hope I'm invited to it, I'd like to talk about social media, because that's up and coming. We've had some cases on it, and there's a lot of can we block TikTok? Can we block things from Facebook and so forth? But that could be another discussion, because the Second Amendment discussion plus the homelessness issue is quite very, very interesting. So thank you.
Well, real quickly, when I spoke with Professor Beery, and he said that sort of the theme that was running through the most recent Supreme Court session and what we would be talking about tonight was this idea that has stare decisis been thrown out the window. And I was reviewing the criminal cases that the Supreme Court had looked at. Normally, the three cases I'm going to mention right now would be of no import. In fact, no one would likely pay attention to these because, believe it or not, the Supreme Court actually ruled with precedent. And real quickly, Erlinger versus United States, the defendant pled guilty to being a felon in possession of firearm, which is a federal offense. It can be charged at the state level too, but it is a federal offense. And in the federal system, sentences can be enhanced if the defendant has a prior criminal history, prior criminal convictions. And there are two ways they can do that. They can do that through the career criminal and the armed career criminal. And to have your sentence enhanced as an armed career criminal, there has to be the requisite number of prior convictions involving a weapon on separate occasions. So saying that, about 20 years, well, 24 years ago, in the case of Apprendi versus United States, is a significant landmark sentencing case that came out of the Supreme Court that said to enhance any factor, any element that enhances a defendant's sentence must be found beyond a reasonable doubt by a jury. And the Supreme Court upheld that concept in Erlanger and said, yes, we maintain that if you're going to seek government to make this defendant's sentence enhanced because he's an armed career criminal, yes, those have to be proved beyond a reasonable doubt to a jury. So they upheld Apprendi, a 24-year-old precedent. In Thornell versus Jones, it's an ineffective assistance of counsel claim. And the seminal case for ineffective assistance of counsel is Strickland versus Washington, which was authored by Justice O'Connor in 1984. And in that case, the court declared a two-part test, conjunctive test, to determine whether trial counsel's assistance was effective. So if a defense lawyer's representation falls below an objective standard of reasonableness, it is deemed that counsel was ineffective. Then we move on to the second part of the test that says, even if counsel's performance was ineffective, to get a reversal of the conviction, the defendant has to show that the outcome would have been different. Well, in Thornell's case, right, in Thornell versus Jones, he was found guilty of premeditated murder and was eligible for the death penalty. And so what became interesting and is I shouldn't say subtext, it is a significant part of the opinion. The court got into how much deference do we give to the courts below analysis of how much weight they gave to the aggravating factors that the government uses to argue for a death penalty and the mitigating factors that a defendant uses to try to argue that his life should be spared. And so that was part of the analysis as well. But again, they upheld the precedent, the 1984 precedent of Strickland versus Washington, and saying, yes, even if counsel's performance at trial, and the issue was he didn't present enough mitigating evidence on behalf of the defendant still has to show that the outcome of that trial would have been different. So again, precedent upheld. And last but not least, real quickly, double jeopardy is alive and well. In a unanimous decision, McElrath versus Georgia, the Supreme Court said that a defendant who was charged with and convicted, let me back up. He was charged with killing his mother, and the government charged that as malice murder, felony murder, and aggravated assault. Prior to killing his mother, I think like a week or two before that, he had been in a mental health facility and he was determined to have schizophrenia. So at trial, he presented an insanity defense. The jury acquitted him of malice murder, but found him guilty but mentally ill on the felony murder and aggravated assault charges. So that's what we refer to as inconsistent defenses. So the issue on appeal was whether or not the government could retry based on those inconsistent verdicts. And unanimously, the court said no. When a jury has determined that the defendant is not guilty beyond a reasonable doubt, that is an acquittal, and there is long-standing precedent that we are not allowed under the double jeopardy clause to retry once somebody has been acquitted. So at least in these particular areas, they are following precedent. So there is a glimmer of hope that they will continue to do that, not just in criminal cases, but other cases as well.
Thanks. And before we do anything else, I just want to say thank you to Professor Fleener for being here. I know you have class at 6. So questions might go a little further. But Professor Fleener, thank you so much for being with us and speaking with us about the administrative law.
My pleasure. Thank you.
Thank you. And I'm sorry, I didn't mean to interrupt anybody. But
No, that's it. I thought I couldn't leave our attendees without some good news coming out of the Supreme Court session.
Very interesting.
Professor Beery, we do have one question in the chat.
okay, great.
And
Sure.
this is for Professor McDaniel. While it's concerning citizens' guns are getting bigger and more dangerous, how do you reconcile that the Second Amendment is to protect citizens from government when government guns are the biggest?
Well, I don't think the issue respectfully is whether or not government has the biggest guns. I think that the issue has always been and will always continue to be those cases in which the government, whether we're talking law enforcement or the military or state guard, as we were talking before, whether or not they can use those weapons domestically. And there's some pretty strong constraints, I think, on both but separate constraints on law enforcement and on the military in terms of using weapons using weapons domestically, using them against civilians. We've seen, for example, with law enforcement, we've seen a number of debates on the scope of qualified immunity. Certainly, once there is a court decision in that circuit, that should be the end of qualified immunity for the use of force by law enforcement. Similarly, there's a number of laws preventing the use of the military against citizenry, despite perhaps rhetoric of a former president.
You. There any other comments from any of the panelists before we take our leave?
Yes. Again, thank you very much for inviting me. This is quite interesting, and I've got a lot of questions maybe for future panel discussions.
Well, we'll definitely do this again.
Yeah.
Thank you for being with us.
Well, thank you for inviting me.
Director Mullins, so I turn it back over to you.
Yes, you can. Thank you, everybody, for joining us this evening for Constitution Day. It is our privilege to host this event each year, and we hope you've enjoyed it. Continue to look for wonderful programming by Cooley Law School, whether it be advertised through Cooley or our wonderful professors appearing via different news channels and other outlets. Thank you, everybody, and have a wonderful evening.
Great. Thank you.
Thank you. Good night, everyone.
Thank you, everyone. Good night.
Good night.